My client was shaking and crying on our Zoom consultation. I didn't hit him back, and I didn't leave either. I stayed for 5 years, and I never told anyone. Not my friends, not my family here, not my family back home. She submitted her VAWA case on her own because somebody told her that she could, and she just got a request for more evidence. Essentially, the U.S. government wants to know a little bit more about your case. They want more information or more evidence or documents that support your claim. An RFE, it's not the end of the world. It's not a denial, but it's going to take some work to overcome it. And this particular client's case, the RFE said that she didn't submit enough proof of extreme cruelty. So extreme cruelty, that's a legal phrase. You might think to yourself, I definitely experienced extreme cruelty, but what the government wants us to show is that you meet the legal definition of extreme cruelty. When she got her RFE notice in the mail, that's when she picked up the phone and called our office. That's why I'm making this video today, because VAWA is powerful, but it's also a complex type of case. And the biggest problem, it doesn't come from people lying. It comes simply from clients not understanding how immigration thinks. Hi, I'm attorney Jennifer Bennett. I'm an immigration attorney here in the Chicagoland area. I've helped hundreds of people get lawful status through VAWA. By the way, my office has a 99% success rate on these types of cases. If you're applying for VAWA or thinking about applying for VAWA, let me walk you through these 5 mistakes that could destroy your case. Mistake number 1, thinking that VAWA is only for physical abuse. If you've never been physically hit, but you've been isolated, controlled, manipulated, you might still qualify. Immigration recognizes extreme cruelty, not just bruises on your body. That means things like being consistently threatened to be deported by your partner, having your documents withheld from you by your partner. They take your passport or your birth certificate and refuse to give it to you. Being financially controlled. Either they're irresponsible with the household money or they control all of the money. They don't let you have any of it. Here's the key. You have to be able to describe it properly and have the right documents to prove that it's true. Honestly, most people don't even realize that what they experienced is abuse. Here's the thing, USCIS is not going to explain it to you, but a good immigration lawyer like myself will take the time to explain to you what the government's looking for. Mistake number 2, not writing a strong personal declaration. Honestly, this is one of the most important parts of your VAWA case, and it's often rushed. I've seen declarations that are 1 paragraph long, or even worse, they just say, he was mean to me. That's just not going to cut it. Your declaration really needs the full story. How you met, what the courting process looked like, how the relationship was in the beginning, when the abuse began, how the abuse unfolded, and what it looked like when you finally left. It needs to sound like you and your words, not like a lawyer wrote it. A good law firm like ours will help you to tell your story in the right words so it feels like you and not in legalese. Mistake number 3, submitting only police reports and court documents. Most VAWA applicants don't actually have police reports or court records, and guess what? That's okay. That's not always what immigration's looking for. What they're actually looking for is a pattern of abuse, and that can be proven through things like a therapist report, which will detail the emotional trauma that you've experienced, statements and affidavits from your friends and family that you called for help during your marriage, screenshots of conversations between you and your spouse where he's being cruel to you. The biggest key here is that your evidence has to tell the same story that your declaration tells. So let me give you an example. Let's say that in your declaration, you explain to immigration that about a year in, he started to beat you. But your friend's affidavit says that the problems didn't start until year 5. That's inconsistent. It doesn't need to be dramatic. What it needs to be is true, honest, believable, and consistent. Mistake number 4, waiting too long after you separate to start your VAWA case. If you've already divorced, you can still file for VAWA, but you must do so within 2 years of the date of your divorce judgment. If you're still married but you're living apart, that's also fine too. But many people wait for too long because they're scared or they're unsure, and then it becomes too late or too difficult. So I had a client that I saw the other day that came in for consultation, and he wanted to apply for a VAWA. He had a horrible marriage. His wife was terrible to him. He definitely experienced physical, emotional, and mental trauma. However, when I looked at his divorce decree, he had divorced 2.5 years ago. It was too late. And it's so sad because if he had come to me just 8 months prior, I could have helped him to self-petition for his green card. If you're listening right now, I don't want you to wait. Here's the thing. I don't make up the deadlines. The government does, and we're bound to these deadlines. So don't wait until it's too late. An attorney like myself can help you determine whether to file now or later, but don't let fear cost you your eligibility. Mistake number 5, thinking USCIS is going to understand what you're thinking. This one breaks my heart. I will see somebody put together what they think is a good statement with a few documents, send it in, and presume that immigration will understand the story. But immigration officers are not therapists. They're not experts in trauma. They're not going to fill in the gaps for you in your story. If your story isn't clear enough, or your timeline doesn't make sense, your documents make things seem inconsistent with your story, your case could be denied. Not because you're lying, but simply because there was not enough in your file for immigration to approve the case. A good immigration lawyer can help you to actually connect the dots, to put your story together in the right way so the immigration officer will understand it. Look, VAWA is honestly one of the most powerful protections we have in immigration law, but it's also one of the most misunderstood types of cases. You don't need to go through this alone. If you've already filed and you're not sure if you did it right or you're considering filing, let's talk. Use the link in the description or drop a comment below. We will be happy to help you figure out what your next step is. You deserve safety, you deserve clarity, and you deserve a case that's done the right way. I'm attorney Jennifer Bennett. I'm an immigration attorney here in the Chicagoland area. I've been helping immigrants for over 15 years, one visa at a time.